Right, I welcome members to the 26th meeting in 2012 of the Subordinate Legislation Committee and ask members to turn off any mobile phones. I can advise the committee that its annual report for 2011-12 will be published today. I believe the report demonstrates the good work this committee is undertaking in its efforts to improve the quality of subordinate legislation. I also note that today may not be a good example of that. Agenda item 1, instruments subject to affirmative procedure. Scotland Act 1998, modification of Schedule 5, Number 2, Order 2013 draft. No points have been raised under any of the reporting grounds, but the committee may wish to refer the following matters to the lead committee and the Parliament for consideration. Scope of the reservation. Firstly, Article 2 of the order modifies the reservation of social security schemes set out in Section F1 of Schedule 5 of the Scotland Act 1998. The new exception to the reservation makes clear that once the order comes into force, the subject matter of Section 69 of the Child Support, Pensions and Social Security Act 2012 will remain reserved. However, Section 69 is to remain reserved as it will read on the date on which the order is due to come into force, which is the 1st of April 2013. As this date is in the future, and as the Scottish Parliament does not have the power to control the subject matter of Section 69, at the point that the Parliament is being asked to approve the terms of the order, it is not clear what subject matter is being reserved by this provision. As to the extension of functions, Article 3 of the order modifies existing devolved statutory functions of the Scottish ministers and the local authorities so that from the 1st of April 2013 they are to have effect as if the transfer of legislative competence by Article 12 of the order had had effect at the time the functions were conferred. Purpose of Article 2 is to confer legislative competence over community grants and crisis loans on the Scottish Parliament with effect from the 1st of April 2013. By giving effect to Article 2 in this manner from that date, Article 3 makes provision that would be within the legislative competence of the Parliament on that date. The Parliament should therefore be clear exactly what the effect of Article 3 is intended to be if legislation is being made on its behalf by order promoted by the Scottish and UK governments. Policy note submitted by the Scottish Government indicates that the intention is for the local authorities and the Scottish ministers to make provision for the new devolved matters of community care grants and crisis loans through the exercise of their powers to advance well-being under the Local Government in Scotland Act 2003. If that is the case, it is not clear why the exercise of the government's new competence under Article 2 needs to extend more widely than those specific provisions to any pre-commencement devolved enactment. Without an exhaustive review of the statute book, it's not clear what the full effect of Article 3 will be. Is the committee therefore agreed to refer these matters to the lead committee and to the Parliament? The lead committee and the Parliament may wish to seek an explanation of these matters from the Scottish Government to inform consideration of the draft order. John?
I mean, I'm unhappy about the inherent uncertainty as to the scope of what will be reserved, and essentially I feel that we're being invited to approve essentially the issuing of a blank cheque here. Choose my metaphor carefully, but nonetheless I think that it's well worth drawing attention to the government.
I think John Scott is correct, of course, but I think I can see the timing issue because as this will affect the budgeting for an operation of local authorities and government from the beginning of April, it is necessary to give some legislative certainty well in advance of that, even though there is the strict possibility that there may be some uncertainty introduced. But then I think it is not dissimilar to where we as a Parliament pass legislative consent motions, which essentially say it's our right to legislate, but Westminster, you may do so on our behalf, where on the basis of trusting and prior agreement that things will be done in a proper way, we do proceed. So I think the important thing that's in this issue is not the substantive matter, but simply making sure that the appropriate committee understands that that's the effect of passing this order, that it is in effect to hand responsibility to Westminster to do things in a proper way. And I think that's the thing that we should be reporting. I certainly can see the case for doing things on the kind of timescale that there are, unless I'm misunderstanding.
I agree with Mr. Stevenson entirely, but nonetheless we're being asked to approve something that we know not what it is.
Indeed, which is why I think we're being asked as a committee to refer this to the lead committee, because that element of policy is clearly for the lead committee rather than ourselves. So are committee members happy that we refer that to the committee, to the lead committee in those terms? Thank you very much. Agenda item 2, instruments subject to negative procedure. We begin with the Adults with Incapacity Public Guardians Fees Scotland Amendment Regulations 2012, SSI 2012-289. Column 3 of the table contained in Schedule 1 sets out the fee currently payable for services provided by the public guardian. In entry 19 of the table, the fee currently payable for estates valued between £250,000 and £500,000 is £800 and not £600 to £800 as stated in the instrument. And similarly, in entry 20, the fee currently payable for estates valued between £250,000 and £500,000 is £860 and not £660 to £860 as stated. Since these errors relate only to a statement as to the existing fee, it seems unlikely that they will have any effect on the operation of the instrument. However, if it is normal practice to indicate the existing level of fee within the instrument so that readers can identify the changes to fees which are being made, members might consider that the purpose has been frustrated by these errors. Members may wish to report the matter for that reason, or because this instrument is one of a series of instruments revising court fee levels, 4 of which contain pen drafting errors. When taken with the errors identified with the other fees instruments being considered by the committee at this meeting, a broader question arises as to whether an adequate standard of quality control has been applied during the drafting process for this series of instruments. Does the committee therefore agree to draw this instrument to the attention of the Parliament under the general reporting ground, as it contains 2 minor drafting errors?
Agreed.
We do, thank you. The committee now turns its attention to those other fees instruments containing drafting errors. The Court of Session, etc. Fees Amendment Order 2012, SSI 2012-290. The drafting of this order appears to be defective. Article 1.2 brings Article 5b into force on the 1st of April 2013, when Article 5a ceases to have effect. Article 1.3 brings Article 5c into force on the 1st of April 2014, when Article 5b ceases to have effect. There are no such paragraphs A to C in Article 5, and it is clear that the order should have referred instead to the relevant paragraph of Article 6. The effect of this is that the increased fees under this instrument cannot properly be charged. Does the committee therefore agree to draw this order to the attention of the Parliament on reporting ground I? Thank you. Does the committee also welcome the fact that the Scottish Government has undertaken to lay an amending order to correct the errors prior to this order coming into force? There is a minor drafting error in Part 2HI1 of the Table of Fees in Schedule 1 in Column 3. The fee formally payable for registering a case and receiving and delivering up a bond of caution is narrated as £2,035, when it should be £20 or £35. It's not considered that this error has any effect on the operation of the instrument. Does the committee therefore agree to draw the order to the attention of the Parliament on the general reporting ground? John?
But I would say that this type of inaccuracy may not have any effect on the operation of the instrument, but it will certainly have an effect on someone reading the instrument, perhaps a lay person such as myself, who could at best be easily confused and at worst put off. And therefore I think this is really, this taken in conjunction with the other mistakes that we've already witnessed in this regard, and that we're about to come to, I think it's sloppy drafting at the best, and really something needs to be done to make sure that this does not happen again in future.
Thank you for those comments. Does the committee also agree to welcome that the Scottish Government has undertaken to correct this error in the amending order to be laid to correct the errors in Article 1? Thank you. The High Court of Justiciary Fees Amendment Order 2012, SSI 2012-291. The drafting of this order appears to be defective. Article 1.2 brings Article 3b into force on the 1st of April 2013 when Article 3a ceases to have effect. Article 1.3 brings Article 3c into force on the 1st of April 2014 when Article 3b ceases to have effect. Once again, there are no such paragraphs A to C in Article 3, and it is clear that the order should have referred instead to the relevant paragraph of Article 4. The effect of this is that the increased fees under this instrument cannot properly be charged. Does the committee therefore agree to draw this order to the attention of the Parliament on reporting ground? Aye. Does the committee also, once again, welcome the fact that the Scottish Government has undertaken to lay an amending order to correct the errors prior to this order coming into force? The Sheriff Court Fees Amendment Order 2012, SSI 2012-293. The drafting of this order appears to be defective. Article 1.2 brings Article 2.11b into force on the 1st of April 2013 when Article 2.11a ceases to have effect. Article 1.3 brings Article 2.11c into force on the 1st of April 2014. There is no Article 2.11, and it is clear that the order should have referred instead to the relevant subparagraphs of Article 2.10. The effect of this is that the increased fees under this instrument cannot properly be charged. Does the committee therefore agree to draw the order to the attention of the Parliament on reporting ground? Aye.
Agreed.
Does the committee also agree to welcome that the Scottish Government has undertaken to lay an amending order to correct the errors prior to this order coming into force?
Agreed.
Although the committee welcomes the Scottish Government's commitment to laying an amendment order to correct the drafting errors in these instruments, the committee may wish to draw the attention of the Scottish Government to its dissatisfaction with the overall quality of this suite of instruments regarding court fees. Given the number of errors in these instruments, it appears there must be doubt as to whether an adequate policy control process has been applied in relation to these instruments, and the Scottish Government may wish to reflect on this to ensure that the quality control process is robust. Is the committee agreed to make these points to the Scottish Government?
Agreed.
Thank you. Turn to the Crofting Register Scotland Rules 2012, SSI 2012-294. The form or meaning of this instrument could be clearer in that Rules 6.3 and 4 make differing provision as to the form which is to be used when applying to register a new common grazing. The effect of Rule 6.3 is that such an application is to be made on Form C, while the effect of Rule 6.4 is that it should be made on Form D. Scottish ministers acknowledge that such an application should properly be made on Form D, and that accordingly there is an error in drafting Rule 6.3. On that basis, does the committee therefore agree to draw the instrument to the attention of the Parliament on reporting ground H?
Just, Chair, that the draft is quite confusing, particularly in not only what form to fill, but how to fill the forms. And I think that needs clarity, and I would appreciate if they could focus into that to make sure that they're actually being consistent with exactly what is expected of applicants. But I want to go a stage further and say that if an applicant makes an application on an incorrect form, is his fee protected? Would he be expected to pay a new fee, or would his fee that is already being paid would suffice? Because what I would not want to see is somebody being penalised for not understanding the new system.
Well, I think our legal advisors might be in a position just to comment on that, please.
If it's resistance, I think it is unlikely that if an incorrect form is submitted that the keeper of the registers would charge in respect to that form. It would presumably be returned to the person who had completed it with instructions on which form should be completed, and I would expect that the fee would therefore only be chargeable when the correct form was submitted.
Is there anything in legislation to protect the individual's rights in that way? We're assuming something here, and I'm not sure if I'd want to put somebody at risk by assuming something rather than...
I think there is nothing in legislation to that effect. I think we would have to understand that that is the ordinary practice of one of the office holders within the Scottish administration.
On a different subject, perhaps you may want to finish this.
I'm happy.
I mean, I sat on this crofting bill, and there will be a marked reluctance to register, I'm afraid, anyway, and therefore any confusion that is now surrounding this piece of legislation, crofting legislation, is inherently confusing, and therefore any confusion that we are introducing now should be eliminated forthwith, and I'm certain that the government would want to do that, and therefore lay an amending instrument to correct this in early course, given the reluctance there was to register in the first place.
Looking also at the forms A to G, they are all prefaced as please type or use black ink and capital letters, with the exceptions of forms C and G, which says the form should be completed electronically. But when you look at sections 9 and 10, sections 9 and 10, well, 9.2 says that C and G, which are headed to be completed electronically, nonetheless says they may be submitted on paper, and that seems inconsistent. Furthermore, when you look at section 10, in 10.1, it says that G, which is supposed to be completed electronically, must be accompanied by a paper plan, where the plan is necessary for the keeper to perform functions. But C, which is required to be completed electronically according to the form, but according to 9 may be submitted in paper, you are required to submit by electronic means only the plan in a range of specified formats. So there is substantial confusion as to what is permitted, desired or required in terms of electronic or paper submission. And it does seem in particular that in some cases where you're expected to submit one part electronically, you may permit another part in paper, and that seems unlikely to have been the policy intention that was behind the drafting of this, and I think they should equally be drawn to the attention of the government, so that there are not opportunities for the Commission to reject applications because people have misunderstood, misinterpreted whether things should be submitted electronically or on paper and in what form, because it's not, because I think John Scott's point is correct. This was a sensitive issue during the appropriate primary legislations debates, and I think we should be careful not to create further opportunities for people choosing to misunderstand or actually misunderstanding.
I would just like to make the point that I think part of the rationale for accepting different formats of plans, either electronically or on paper, is for the ease of the applicant who might be referring to a historical survey or whatever that's not easy to capture in electronic format. So, you know, I think we have to take a distinction between, you know, some of the errors in the instrument and other aspects of the instrument that are actually designed to make, you know, life easier for applicants.
I think you make a good point.
Clearly, members are exercised by this, and I think
It's confusing.
I think we adequately make the point that this is confusing and that there are concerns, and given the nature of the subject matter anyway, I think I'm getting the impression that the committee would like to suggest to the government that, given that this is a brand new scheme, we really should get it clear, at the very least, to start off with.
I understand, Convener, that there would be time without compromising the operation of this for the government to act.
So I think as a committee, we are, our members happy. Hans Alla, sorry.
Sorry, just one additional point in terms of electronic movement of information. Not everybody has easy access to the internet system, particularly up north, and I think that we want to make this order as helpful as possible, which means that we should make it absolutely clear that people actually do have a choice. We may have a preference for electronic movement of information, but I think we need to give people a choice, because at the moment we're not in a position to guarantee people access to the web system, and I think we would disadvantage people in that way.
Can I make the point? I think Form C is intended to be used by the Commission, is that right? And therefore actually wouldn't be used by a normal crofter. But nonetheless, it's all extremely confusing. And I think if members are content that we refer this back to the government, essentially making the point we'd like it to be very clear from the outset, and that really guidance issued afterwards is, in our view, not the correct way forward.
And you are suggesting that an amending instrument to correct this error is made in early course.
I think that's the suggestion, if members are content with that. Stuart?
Just for clarity, I think we are not simply talking about errors, because what I've talked about I don't think constitute errors. It's capable being, I think it's lack of clarity in its expression, and perhaps, and this is a matter for the government, not for us, because we are not about policy, perhaps what is before us does not implement what they actually wish to implement as policy. We can't be certain, but other readers will equally be uncertain. And I think Hanzala's point is a good one too, that with the substantial difficulties some rural businesses are experiencing with a legal requirement to submit that online, we already have an illustration of the difficulties that if we force electronic. We have to get there sometime, but we have to get there when it's possible.
So can I suggest two ways forward? One is that we do report formally on the error. Secondly, that we make the point that we do believe that it should be clear at the outset, given that it's a new statutory scheme. I'm just wondering whether we might separately write to the Minister expressing our concerns, so we can put those perhaps slightly clearer than we will have done now on the record. Just to alert him to our concerns about all the issues. Clearly the policy issue is not ours, but there's an awful lot of practicality in what we've discussed already.
But equally, Convener, given that they are negative SSIs, it is possible to correct them before the coming into force date of 30th November.
The key points of confusion would be the Form C and Form D, existing grazings and new grazings.
Read on that. Thank you very much indeed. Right. I think we've effectively got to there. Am I right? Are you comfortable? Are you comfortable with that?
Yes.
Effectively.
I think we're starting here.
Yes. Okay. Furthermore, and we need to point this out, there's an error in Rule 6.4 which makes reference to Section 26(1)A of the Crofting Reform Scotland Act 2010. That section specifies the procedure to be followed in applying for first registration of new common grazings. The Scottish Ministers accept that this also instead to be a reference to Section 24(1)A, which requires the making of an application to register new common grazings. Does the committee therefore agree to draw this error to the attention of the Parliament on the general reporting ground? We do. Thank you. Turning now to the Crofting Register Fees Scotland Order 2012 SSI 2012-295. The formal meaning of the table of fees could be clearer. Applications for first registration of a new common grazing are made under Section 24(1)A of the Crofting Reform Scotland Act 2010, and so are properly chargeable under the entry for registration of a common grazing under Section 24(1) of the Act. However, a further entry purports to charge a fee for registration of a new common grazing under Section 26(1) of the Act. Section 26(1)A specifies the procedure to be followed if in an application under Section 24(1)A. It is accordingly unclear what effect this second entry is supposed to have, and it's also unclear whether applicants are chargeable only under the first entry or whether both entries apply, and accordingly two fees of £90 each are payable on the first registration of a new common grazing. Does the committee therefore agree to draw the instrument to the attention of the Parliament on reporting ground H? We do. Similarly to the errors in the rules, members may welcome the Scottish Minister's clarification that it is intended that only a single fee should apply to such an application, but may nevertheless take the view that it is not satisfactory to attempt to clarify this ambiguity by way of guidance. I think is. But
reiterate the point, if I may, to the boredom of others perhaps, but since this is a new and very difficult piece of legislation following attempts to reform crofting legislation over a number of sessions in Parliament, I think it would be a great shame if the government didn't take the opportunity to get it absolutely right first time round and eliminate as much confusion from crofting legislation as possible, and do so at the earliest opportunity.
It appears that there is a significant ambiguity within the tables of fees. Does the committee agree to recommend that the Scottish Ministers consider laying an amending instrument to correct this error in early course? We do. Thank you. Turning now to the Justice of the Peace Court Fees Scotland Order 2012 SSI 2012-292. Members will see from the correspondence that two issues were raised with the Scottish Government. First issue relates to the clarity of the drafting, specifying which civil partnerships are to be recognised as falling within the definition of a partner in Article 3.2 of the Order, and so entitled to certain exemptions from liability to pay fees. The Scottish Government did not take a consistent approach as to how civil partnerships were defined in relation to the various jurisdictions within the UK, which might be confusing to readers. While the legal advisers agree with the Scottish Government that the legal effect is sufficiently clear, given the drafting errors identified in the other fees instruments this week, members may wish to comment on the resulting untidiness of the inconsistent drafting approach. Members may also feel they've actually already said enough. Yes, indeed. More significantly, the second issue concerns whether ministers have the power to revoke the District Court Fees Orders 1984, as Article 4 sets out to do. Members have seen the discussion in the legal brief, and in short, the legal advisers do not agree with the Scottish Government's view that a power to revoke previous instruments must reasonably be implied in this case, given that the Interpretation Act 1978 clearly states that such a power is not available. The question is whether an instrument is within VERIS is obviously a serious matter. However, in this case, the legal advisers accept the Scottish Government's assessment of the practical effect of the order. In short, it is agreed that the 1984 order is superseded by this instrument and so no longer has legal effect, although not by virtue of the purported exercise of the power in Article 4. It is also agreed that this has no effect on the ability to charge new fees. It is, I think, important to register the difference of legal views on the matter of VERIS. However, it is accepted that there is no practical effect on the operation of the new fee regime. The legal advisers suggest that members may be content not to formally report the instrument. Do members wish to comment on? We are agreed. Thank you. No points have been raised by our legal advisers on the International Recovery of Maintenance, Hague Convention 2007, Scotland, Regulations 2012, SSI 2012-301. Is the committee content with that instrument? Content. Thank you. Agenda item 3, instruments not subject to any parliamentary procedure. No points have been raised by our legal advisers on the Act of a Journal, Criminal Procedure Rules Amendment number 3, Procedural Hearings and Appeals from Solemn Proceedings, 2012, SSI 2012-300. Is the committee content with this instrument, please? Content. Thank you. Agenda item 4, Social Care Self-Directed Support Scotland Bill. This item of business is consideration of the delegated powers provisions in this bill after stage 2. Members will have noted that the Scottish Government has provided a revised delegated powers memorandum and will have seen the briefing paper and the draft report. Stage 3 consideration of the bill is due to take place on the 28th of November 2012. The deadline for lodging amendments is 4:30 on this Thursday, the 22nd of November. The committee may therefore wish to agree the report today. Does the committee agree to report that after stage 2? It does not need to draw the attention of the Parliament to the amended powers in sections 12 and 21. Yeah. Does the committee also agree to welcome the fact that the Scottish Government has introduced a statutory consultation requirement which must be fulfilled before the powers in sections 12 or 21 may be exercised in order to address the concerns raised by the committee in its Stage 1 report?
Thank you.
We do, thank you. There being no other meeting, the business, pardon me, I can close this meeting. Our next meeting will be held next Tuesday.